Colorado is recognized.
Thank you, Mr. Speaker. I thank the gentleman from Georgia for yielding me the customary 30 minutes, and I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, I rise in opposition to the rule and the underlying legislation. Today, the House is convening to debate a matter that we all agree is critical for our national security, our economic competitiveness, our prosperity, and the success of our private sector. The recent cyber attacks on Sony and Anthem are but two prominent examples of cases in which American businesses or government entities have come under attack by hackers, among many other instances that haven't even been reported. I want to recognize the work that the House Intelligence and Homeland Security Committees did on these pieces of legislation and their attempts to address these issues. Unfortunately, in spite of their hard work and the work of those that went into crafting these two bills, I regret that they fall short of their goals and would likely do more harm than good. Not only do both bills, particularly the Protecting Cyber Networks Act, raise enormous concerns about inappropriate sharing of personal information and surveillance on Americans' private lives, but they're built on the premise that many security experts have warned is fundamentally flawed, that sharing information with the federal government should be the central focus of our efforts to protect American cyber networks, rather than simply one aspect to a multi-pronged strategy to defeat hackers, foreign and domestic. Now, before I address the substance of these two bills, I want to discuss this unusual rule before us and how it treats two bills which contradict each other in significant ways. Ordinarily, when two committees share jurisdiction over a matter, and in this case the Homeland Security Committee and the Intelligence Committee, they collaborate. One committee handles one portion of the bill, reports it out. The other committee handles the other portion, reports it out. And they work together to bring a single piece of legislation to the floor for members to debate, amend, and vote for or against. This is what happened, for example, with the recent SGR repeal legislation, which had components under the jurisdiction of no less than 6 different committees in this body, but was presented before us as a single bill. In this case, however, because there seems to be some kind of turf war between the Intelligence Committee and the Homeland Security Committee, we're actually voting on two overlapping bills that in several respects contradict one another. For instance, the bills have drastically different determinations of what kind of information may be shared, what purposes the government may use the information for, and what hacking countermeasures companies are allowed to take to protect their networks. But instead of having a meaningful debate on the merits of each bill's approach, this body, if this rule passes, would forego that, and we would simply debate and vote on each bill separately, and if they both pass, the rule directs the clerk to mesh them together through something called conforming amendments. Not only would this leave businesses to wade their way through two separate contradictory regulatory schemes, but it leaves it unclear which bill's provisions would actually prevail in practice and under which circumstances. It actually would create more uncertainty in the marketplace rather than less. I don't think anybody could reasonably call this an open process. We shouldn't be depriving our constituents of an open debate on important issues. The major amendments of this bill that would have restored privacy, many of which I was a co-sponsor, are not even allowed to be debated on the floor of the House, not for 10 minutes, not for 5 minutes, not even for 1 minute. My colleagues and I on both sides of the aisle are being denied a vote on the very amendments that we feel could address the concerns we have with this cybersecurity legislation and make sure that we keep American networks safe. Mr. Speaker, in the 2 years since the NSA's shockingly broad data collection program PRISM came to light, we've heard from many of our constituents. The American people want an end to unwarranted surveillance. They want Congress to restore desperately needed accountability and transparency to our nation's often out-of-control intelligence gathering apparatus. So it's bewildering to many people that at the very time the American people have spoken out that we want more safeguards, instead we're bringing forward two bills whose central objective is to facilitate the flow of more personal information to the federal government. when we continue to put off the question of surveillance reform and bringing an end to the NSA's bulk data collection without warrants. It's especially disappointing in light of the fact that several Patriot Act provisions will sunset at the end of next month, giving Congress a crucial opportunity to re-examine and rein in federal surveillance programs. But by putting off that issue and bringing mass information sharing to the floor, Congress is asking the American people for a blank check. Congress is saying, trust the president. No president would allow this information sharing to infringe on your civil liberties, even though we've utterly failed to pass a single piece of legislation to end the privacy abuses that we know have occurred under this administration and the prior administration. The problem with these bills is that they go far beyond and they open up additional loopholes and potential abuses with regards to privacy abuses, particularly H.R. 1560, the so-called Protecting Cyber Networks Act. Both bills open up Americans' private information to inappropriate scrutiny to the federal government. Now, I expect we'll hear proponents of both bills argue at length that the protections against sharing personal information are sufficiently robust. For instance, under both bills, they will cite that cyber threat data is scrubbed twice for personal information, once by private entities before they transmit it to the government, and once by government entities before they store the information or share it with anybody else. Now, that sounds good, but unfortunately the devil's in the details, and a close reading of the bill shows that there is an enormous loophole in the information scrubbing component, and that it fails to offer Americans safeguards for the personal information. Under both bills, any federal entity in receipt of cyber data threat information may store and share personal information it receives, unscrubbed information, if they believe that it is related to a cyber security threat. Now, this standard isn't just too vague, considering what information is related to a cybersecurity threat could be interpreted to mean just about anything. It's also incredibly broad. It includes an implicit assumption that Americans' personal information should be shared, unless federal officials have information that it's not related to a cybersecurity threat. So in many cases, the burden is to show that the personal information is not related to a cybersecurity threat for it to be scrubbed, rather than the other way around. So yes, companies and federal entities are required to quote-unquote scrub data for information that can be used to identify a specific person, but the loophole then calls on them not to remove personally identifiable information unless they can show that it's not related to cybersecurity, even if there's an off chance that something at some point might be pertinent to some kind of investigation. It puts Americans' personal information without warrants, without due process, including information about patterns of internet use, location, content of online communications, at great risk. We've seen before that the federal government has a poor track record of safeguarding our personal information when they're entrusted with it. The last thing we should be doing is empowering federal agencies even more with the broad discretion to look at personal information unless there's clear evidence that doing so would combat a cybersecurity threat. Now, I introduced, along with my colleagues on both sides of the aisle, a number of amendments to both bills. One I introduced with Representative Zoe Lofgren, and one with Representative Zoe Lofgren and Representative Justin Amash to impose a higher standard on federal entities who are entrusted with personal information. Our proposal would simply have required the government to remove personally identifiable information unless it was directly necessary to identify or mitigate a cybersecurity threat, the purported purpose of this bill. These amendments would have imposed no additional burden on private companies, but they would have given our nation's technology companies and customers who keep them globally competitive more confidence that private information shared under these bills would not be subjected to inappropriate mass scrutiny by the government. Sadly, our amendments met the same fate as nearly 24 others put forth to add in important privacy safeguards. The potential for abuse of private information under H.R. 1560 is even more far-reaching. The Homeland Security Bill at least makes clear that the information companies transmit to DHS should be shared specifically with other agencies that need it to protect critical infrastructure, but the circumstances under which information can be shared under the Intelligence Bill and who it can be shared with are fuzzier and broader. Under the approach taken by H.R. 1560, every cyber threat indicator shared with a civilian agency of the federal government is immediately shared with a host of other government agencies, including the NSA. This increases the threat to cybersecurity by having repositories of information replicated across numerous government agencies, creating additional avenues for attack by malicious hackers. That means that private sector companies will not be able to participate in the program and promise their users they will not share information with the NSA or other government agencies unless required by law. Furthermore, it's true that the Homeland Security Bill includes some troubling provisions that allow the government to use cybersecurity threat information for criminal investigations unrelated to cybersecurity. Fortunately, the Rules Committee made an order amendment by Representative Katko, Zoe Lofgren, and Anna Eshoo that would address this problem in the Homeland Security Bill. I hope that my colleagues adopt this amendment. Unfortunately, no such amendment is being considered to address this issue within the Intelligence Bill, H.R. 1560, where the problem actually runs much deeper. H.R. 1560 permits cyber threat data, including Americans' private information that's shared with the federal government, to be stored and used for a raft of unrelated purposes, unconstrained by congressional directive, including investigations and potential prosecution of crimes completely unrelated to cybersecurity. Obviously, all of us want law enforcement agencies to be equipped to prevent and prosecute violent crime, but the inclusion of these matters completely unrelated to cybersecurity broaden the scope of the measure far beyond what it's purported to be, a cybersecurity bill. In fact, it reduces the focus of our efforts on combating cybersecurity when you open it up to everything under the sun. By including a vast array of other reasons the government can invoke to store and share personal information, the authors of the bill essentially transform the information sharing initiative into a broad new surveillance program. Yes, rather than a cybersecurity measure, effectively these bills are a stalking horse for broad new surveillance authority by multiple agencies of the federal government without warrants, without oversight. H.R. 1560 empowers federal entities to hold on to any information about an individual that may be related to any of the many law enforcement purposes lumped into the bill. That gives the federal government enormous incentives to retain and scrutinize personal information, even if it's unrelated to a cybersecurity threat. The scope of the use authorizations also undermine due process protections that exist to protect Americans against unwarranted search and seizure. Private information about a person that was transmitted warrantlessly to the NSA under a program that was purportedly designed to combat hackers should not be admissible or used in court against them on an unrelated offense, not related to cybersecurity, not related to hacking. It would render all of our due process protections invalid simply because of the medium of the information that's used with regard to these matters, in this case, internet and cyber-related mediums and communications through them. I joined Representatives Zoe Lofgren, Darrell Issa, and Blake Farenthold on an amendment to make clear that information sharing may only be used for the purpose of mitigating cybersecurity threats. Again, the purported purpose of this bill. If the proponents of this bill are serious about combating cybersecurity, why did the Rules Committee deny members the opportunity to limit the provisions of this bill to cybersecurity rather than a whole host of unrelated offenses? I also joined Representative Kevin Yoder to sponsor an amendment to address a longstanding due process issue that's plagued our nation's legal system and our privacy rights. While the government is required to get a warrant if it wants to search through your physical mail, it's not required to get a warrant to search through somebody's old emails, provided the emails are older than 6 months. That contradiction and loophole is based on a 1986 law that was written before most people knew what email was. Representative Yoder and I sponsor a bipartisan bill that has 261 co-sponsors, and yet when we offered a provision on this bill, we were not given a chance to vote on it and pass it in spite of the grave due process implications that the underlying legislation has. Now, in addition to these privacy and due process concerns, I'm alarmed by the prospect that H.R. 1560 will actually invite attempts by both private and public entities to deliberately weaken the integrity of software systems in the name of cybersecurity. H.R. 1560, for instance, authorizes companies to deploy countermeasures that are called defensive measures in the form of hackbacks that would otherwise be illegal. A countermeasure operated on one network should never cause harm to another. That's prohibited by the federal anti-hacking statute, the Computer Fraud and Abuse Act. But that's precisely what can happen when a company places malware on its own network, because if that data gets stolen along with other valuable data, it can harm or lead to unauthorized or backdoor access of other proprietary networks or information. Now, Representative Jerry Connolly put forward 2 amendments to address this issue in a very thoughtful manner. Regrettably, neither one will be allowed to be debated or receive a vote on the floor of the House unless we can defeat this rule. Furthermore, both bills present the risk that federal entities will use the threat information they receive from private companies to circumvent the security protections safeguarding those same private companies' information systems, effectively creating their own backdoors, which could later be exploited by malicious hackers. As a matter of routine, our intelligence apparatus already demands that private companies include defects in their encryption system for the purported purpose of conducting backdoor surveillance. Today's legislation makes it easier for the NSA to find and exploit more of these backdoors, and therefore easier, not harder, for hackers to find and exploit these very same security weaknesses. Once again, Representative Lofgren put forward an amendment that would actually improve cybersecurity by making it clear that federal entities cannot use data obtained through information sharing to demand that private entities create new encryption weaknesses to enable backdoor hacking. Sadly, once again, her amendment will not be heard on the floor of the House, and this bill will encourage and allow additional venues for the very illicit hacking it purports to combat. Mr. Speaker, I don't doubt the intentions and the goals of my colleagues on the Intelligence of Homeland Security committees, but these bills simply present step backwards rather than step forwards, present risks on too many fronts, from privacy to due process to the threats that they add to the integrity of the very networks that these bills are designed to safeguard. In addition, the bill's focus on information sharing negates an important conversation about more important mechanisms Congress should be looking at to protect cyber systems, mechanisms that are not as fraught with risk to our civil liberties and are more effective at protecting our networks. We should be doing more, for instance, to educate businesses and governments about basic network security. Even here in Congress, we've seen evidence of how woefully lacking even elementary knowledge about cyber threats is. Helping businesses prevent cyber attacks doesn't have to mean that the government vacuums up endless amounts of personal data about how individual Americans are using the Internet and their personal communications. In fact, if we stopped allowing the NSA to demand that U.S. businesses deliberately weaken their own networks for the purpose of government surveillance, that in itself would be a big step forward to strengthening our national cyber security. Sadly, today's rule doesn't even allow debate or voting on the most significant concerns surrounding this legislation, denies members the opportunity to consider changes that would address the issues that we've raised and improve cybersecurity under this bill. And for these reasons, I hope my colleagues join me in opposing the rule and the underlying legislation, and I reserve the balance of my time.
Gentleman reserves. The chair will receive a message.
Mr. Speaker, message from the Senate.
Mr. Speaker,
Madam Secretary.
I have been directed by the Senate to inform the House that the Senate has passed S. 984, cited as the Steve Gleason Act of 2015, in which the concurrence of the House is requested.
Gentleman from Georgia is recognized.
Thank you, Mr. Speaker.